Hey guys, good afternoon. It's a pleasure to be here. My name is Kernen. I am an entertainment and intellectual property lawyer on the transactional side of things that primarily operates at the intersection of what I like to call culture and blockchain. So I am doing a lot of work on behalf of entertainment clients that are looking to move into the blockchain space, and then also bringing sort of crypto native culture clients, bringing their visions to life. Based here in Philly, got my own shop, so that's it. Ariel?
Hey everyone, I'm Ariel Givner, founder and principal partner of Givner Law. I represent DAOs and a lot of small companies that are really starting out and trying to get in the blockchain sphere. And I too have my own shop located in Cherry Hill, but also in Philly. South Jersey native forever.
Hi everybody, my name is Sorokin. I am an associate at the law office of Simon Rosen, also an entertainment law firm based in the Philly area. We do a lot of entertainment work on the litigation side, also on the transactional side, and we're working to build out the blockchain Web3 practice, working with some clients right now who are involved in token listings, a DAO, an NFT project, so sort of getting our feet wet in that world, tying in the legal principles from the entertainment world, and figuring out how it all taps into the NFT Web3 space.
So, inferring from their interests alone, they're pretty smart people compared to me over here. So, we'll keep it interactive.
You're being real presumptive. Yeah, we paid him for that. That's why we're in the hallway.
So, to keep it interactive, I'm going to be asking a lot of questions, but if you guys have any questions about my questions or their answers, feel free to raise your hand and ask. So, to kick it off, the first question is, smart IP is generally created by recording IP rights on a distributed ledger, aka blockchain, as opposed to a traditional database. Is this valid? And if not, would smart registries help?
So I'll take the basic of the question and then I'm going to give it to Ash for more complicated answers. Long story short, I think that having the IP information on the blockchain is incredible, but if you don't federally register it, so if it's a trademark, if you don't federally register it with USPTO, it's really not going to matter. I think it's very cool to have a timestamp and have it always presentable and, have the metadata and not have it be altered, but at the end of the day, you're not going to be able to sue for infringement or claim anything like that unless you federally register it. The same is with copyrights. And even though you might say, who the owner of the copyright is, et cetera, again, unless you register with the United States Copyright Office, you actually can't sue for infringement, which is a fact that isn't known enough about copyrights. They're automatically created, but unless you register it, you cannot sue for infringement.
Yeah, so I've been doing some really cool work lately in on-chain licensing and rights sort of management. I love the question because I do think it's the future of sort of IP rights transfer, so forth and so on. But Ariel is on the money. Like, until things change at the end of the day, vis-a-vis the supremacy clause, federal law stands. And as far as flat out modified indicia of ownership and everything, federal registration still triumphs over everything. It's what we call sort of a burden shifting mechanism, which if I show up in court and I have the federal registration, then if the onus falls on the other party to prove otherwise. That being said, however, what is really dope, and I do think that smart IP is the moniker is known as, is that I do think that we will be able to sort of move rights around on-chain, and it could definitely serve as downstream indicia, what we call sort of extrinsic evidence. It's like supporting evidence of ownership. And I've done some really cool hybrid on-chain licensing this year where we are sort of wrapping rights in an NFT, in a living, breathing smart contract that pings an oracle and updates it. It can update. So, for instance, you guys asked the question earlier in one of the prior panels, which was dope, about dynamic NFTs. And so I was thinking about work I'm doing on behalf of a client that has a royalty provision for some music rights in it, and we have performance kickers in it, right? So the smart contract pulls in off an API and looks at how many plays. So you think like in the traditional 2.0 music world, you go diamond, you go platinum, you go gold, you go silver. In my case, you go rock. There are 5 people that listen to my music, but anyway, plug shameless. But in this case, the royalty percentage that gets kicked out in the smart contract can increase based in real time. So there's some of that cool kind of sort of IP stuff going on, but in terms of, and Lewis, I'll interview for some of this, but an interesting challenge that we're currently facing is sort of proving that signature in a wallet satisfies the writing requirement under sort of the Copyright Act to transfer over ownership rights. And it's my feeling that ultimately it will, but one of the challenges is, as we all know, we live in this sort of anonymous ecosystem where people, for some fucking reason, continue to hang, excuse me, I guess I shouldn't be cursing here, sorry. It tells you what kind of lawyer I am. Yeah, where it's anonymous. So how do you prove that the person who signed that transaction is actually the person bringing the claim in court or trying to enforce their rights under the contract, and vice versa, the person on the other end bestowing the rights, how do we get to them? So there's definitely some challenges, but I do think it is the future.
So as this passes on to Lewis as well, I'm gonna question, so I know first use trademarks are a thing. Do first use trademarks apply to what's on chain as well? So just to add on to the question.
So I guess I want to clarify, what do you mean by first use trade? So the idea that a trademark has to be first used in commerce and be superior over another, is that?
So I'm referencing more so the validity of, let's say I came up with something, mailed myself the logo, and started using it. However, I never registered it. However, someone saw the logo and decided to register that. Who owns that at that point?
Yeah, so I mean, to that, we would really look towards what are the evidences that can be presented to show that the mark has been used in commerce, and this is where kind of what people look at with Web3 versus traditional law, there really isn't much of a distinction once you get into a courtroom, because judges don't really know the difference, and they don't really care to know the difference. They just see it as a fact pattern based on laws that have been in place for potentially hundreds of years. So to the point of trademark law, if you can prove, whether it's through mailing yourself a logo or doodling it in your notebook or minting an NFT, that you were the first user in a stream of commerce, then yeah, you would be able to register that mark and you'd be able to protect it in court. I think what we get to more interesting, where we get to more interesting issues with that is kind of when you factor in the NFT piece of it, what are the implications when something is on a distributed ledger versus when it's just in the IPFS, and what are the pieces of it that are on-chain versus off-chain, and there's kind of this blurring of the lines in both the discourse and in the kind of implementation of it of, well, what really is the NFT, and so I can turn it over to Ariel and Ash for kind of more details on that, but I think that's kind of where these issues are popping out right now, is that nobody knows exactly at the moment what the law is going to say for, let's say, is an NFT proof of use in commerce? Probably, but I don't think that's been tested.
And I wanted to kind of talk about something Ash said regarding anonymity in the Web3 space. I've had a strange amount of requests lately from potential clients that want to utilize my services but not dox themselves to me. I've had a couple other attorney friends that are experiencing this as well, and my legal advice, literally to all of you here, is good luck finding an attorney if you aren't going to identify yourself. For many reasons, but I can't name a single attorney that will file a complaint using a Twitter handle. Now, there are reasons sometimes where complaints are not doxed and they do contain identities such as Jane Doe and John Doe, but I cannot think of a use case for that in Web3. So that is just I'm very oddly passionate about doxing yourself when using legal services.
So I actually have a follow-up question for you on that. What would you do if you were up against an entity that is hiding behind a corporate facade but is refusing to dox the individuals behind that?
Fun question. Am I using my degen hat or my lawyer hat? Because I know a lot of people that can hack things.
Give me both.
I would spend money to figure out who's behind it. Because nobody is truly safe from anonymity if you boil down to it. And there are quite a lot of expert services that can help you with that.
Okay. So just being a little bit facetious earlier, as lawyers we understand the use case and the actual rationale. We're being a little bit hyperbolic up here about why would you want to be anonymous. Again, we're all degens in many ways, so we get that. But when we put the lawyer hat on, things become much more difficult to advocate on behalf of your client when you're working with anonymity, because in the 2.0 world, that's obviously still where we're at there. So it's not to say that we're completely unsympathetic to that, but from our perspective, it makes things a little bit more difficult.
100%, and I do have some clients that aren't doxed fully, like whether it's Twitter or YouTube or whatever, and that's fine, they'll dox to me, and in my brain, their identity is considered confidential, attorney-client privilege, so I am obligated to not share that. But at least personally, I'm not going to take on a client unless they tell me who they are. And that's not because I'm nosy or I like the gossip, but it is an ethical thing, and it can be an issue for us with our license if we are accepting a client and, I don't know, you could be some gang member out of like, I don't know, North Korea or something. I don't know who you are. I need to know who you are. Not that a lot of things can be taken out of context here, so just, roll with it.
Back to the provable question of whether an asset is to someone or not. If someone were to have to prove a certain asset is on a chain and they were to put it in a court of law, would they need to have like not only the public address but certain characteristics of them, of like maybe their storage or how they're actually holding assets or parts of their address that may be part of public and private key cryptography to also prove that in court of law? And if that were to happen, then that would mean some type of addresses would be held in the public record, but were meant to be private because someone was trying to either stay anonymous or to keep their private information for how they're interacting or transacting with crypto. I'm curious if there's.
Sure, it's a great question, and so I think the default legal answer to most questions is it depends. And I know I get some trouble from this, but every lawyer that you say that around, but it's really true. In cases like that, those are the types of questions that are typically coming from people who are the people making these products, the people involved in the space, the real degens of the room. Whereas when you get to the lawyers, to the judges, to the juries, they don't understand it. They don't need to understand it. What they need to really get to is the core of what's happening. And so, to the extent that some of that information might be useful towards proving whatever piece you're proving, then maybe some of those details, some of those framing pieces of it, like what blockchain is it stored on, what type of wallet do you access it through, maybe those would be useful for just sort of helping understand what's really happening here and demystifying blockchain to lay people if you're trying to explain it to. Besides that, I don't really see a situation where you would need to disclose your cryptographic keys or anything like that to a jury, to a judge in filings. And if you did for some reason need to, then things can be filed under seal and confidentiality can still be maintained. And we see that all the time with government issues and classified documents. We see that with
So
the
in that
Donald
case,
Trump case
filing
right
a
now.
seal could be relevant for attribution of original assets that are digitally uploaded.
It's possible.
Cool.
Question?
Back to copyrights. If I'm an artist and I create work and I mint it, and because I'm smart, I also send it to the Library of Congress, do things the old-fashioned way, I'm safe. If I make a generative art project that has 999 outputs, that we don't know what they're going to look like until they are actually made. What is my copyright process to secure each one of those unknown, yet you can get unborn outputs?
Alright, buckle up, here we go.
Yeah, if we're talking traditionally,
So,
you would have to register all of them.
but one of the problems and one of the issues is, if you guys know the Chris Castronova guidance, that the Copyright Office is refusing to register completely sort of generative AI-driven outputs.
Not AI.
Yeah, but algorithmically created. And so, number one, there's sort of jurisdictional issues because the UK has different sort of copyright recognition or the genesis of artwork than, say, the US does, even though most everybody's subject to the Berne Convention. But without getting in the weeds, the short of it is this. Feel free to chime in. There is an open question about the registrability in the first instance of whether those are even entitled to copyright registration. And we have this conversation all the time, and it's why there's a consensus. It's why when Yuga was going after Pauline Ryder, they brought a trademark case and not a copyright one. because the compilation of the ape images was done algorithmically. And so, by contemporary guidance, at least to my opinion, if I was a betting man, I would probably say that the Copyright Office is going to refuse to register those images based on the whole. Then we have to go back to the traits. The traits themselves are hand-drawn, and ostensibly, provided there's enough artistic, there's enough original art in that. You know, if they just drew a star, it wouldn't be. It's in the public. You know, sort of seems fair in the public domain. But short of it is, back to your hypothetical. It appears that right now the copyright is unless there's human input on it. So what I'm getting at is there's an issue before we even get to where you're at, or it's in the stew, and it's not totally clear. We haven't seen 100% where the algorithmic, but because if you're the author of the computer program that does that, then there may be merit to the idea of like the outputs are a direct result of your human labor, and that is a requirement under federal copyright recognition.
And just to break that down a little bit further, just because I know we don't all have IP terms memorized, it's okay. A copyright, by definition, is an original work of authorship, and it has to be created with, it has to have human creativity in there, which is why the generative art, the AI art, is being put into question, because how much modicum of creativity by a human is actually involved. So like Ash said, where that individual is drawing those traits and those things, they're ultimately being combined by a computer program algorithmically. However, if you create that computer program, does that count as that human creativity? So I think that this is something that is, like most things in Web3, and unfortunately in this world that we're in right now, because these issues are so new, this is going to be eventually decided and discussed. We're not there yet. And
I mean, you're getting granular, which is cool, but I'm actually not talking about the PFP thing where, okay, the 3D glasses and the VR glasses and the device were actually drawn by somebody. We can, we have anticipation of that. I'm talking about purely algorithmic.
Yeah, straight algorithm.
Not AI. Not AI, it's the same
Right.
thing. Algorithmic, generative, so there aren't pre-configured 3D glasses. There aren't any elements that are pre-configured. They're then shuffled around and put together. I'm talking about the whole thing is generated, and it's absolutely by the algorithm and my code.
Right, it's a question, and the short answer is, I personally don't have the answer on that. It's a good question in terms of, if you are the full human author of the program that ultimately is responsible for the output,
Right.
whether you're entitled to protection over those. I know there's case law on it, I'd have to look it up, to be honest with you. Sorry for, I don't personally have the answer.
it's a really good question. It's a really good question.
Thank you.
And it's not one that's a yes or no answer or a go do this. It's definitely something that,
So you're saying it's still out there, like there's no definitive answer to the best of your knowledge?
To the best of my knowledge, there's not, but it doesn't mean it isn't there. I'm admitting.
I'm in the same boat. I don't know of any definitive answer, but there's been a lot of conversation in the last couple of months about sort of when you get to the generative side, what are the implications of copyrightability, how much human input is enough human input. And the Copyright Office did issue guidance on this that basically says they recognize that technology has been a tool for creativity forever. That's always been the way it's been. They don't want to get in the way of that to an extent, but they don't want it to be that you can put a line of text into, pick your generative tool of choice, Photoshop,
Midjourney.
Midjourney, whatever it is, and have it spit out something and then register that with the Copyright Office. So we saw that with the Ariel of the Dawn graphic novel that Ash was talking about before.
Chris Cashinova case.
Yep, exactly. And so with that, there's this sort of outstanding question, and there are going to be those outstanding questions for some amount of time.
And it is when you use and I know this isn't what you asked, but when you use, let's say for example, Midjourney, the attorney for Midjourney is actually my friend, and they have an irrevocable license on the images created by Midjourney. So it almost prevents somebody from creating something with Midjourney and then applying for sole copyright ownership on that behalf. So there are ways that AI companies, and I don't know if there's a computer generative program for art that just sits out there. Like if I draw a bunch of traits and I'm like, I want this to become a PFP generative project, is there a software out there I can use? So I don't know, because I'm not an artist, so I don't do that, but it might be a case where if there is.
Yeah.
So I wonder if their licensing is the same, but yeah, that's a really good question. Do you want this?
No, just to say that there are European countries that do recognize copyright in algorithmic output. I have to give the answer.
So, onto a question that might be a little bit more definitive. If I were to create an NFT myself, not using an AI or algorithm, and I put it on a chain, would that mean I own the copyright at the end of the day?
So that is one of the more definitive questions. The answer to that is no, you do not. To own the copyright to something, you have to actually create it using some amount of human authorship. Simply throwing it into an algorithm just
Doesn't say you drew it.
Yeah,
Yeah.
sorry, then
Yes.
I missed that part of the question, I'm sorry about that. Then yeah, if you drew it, if you did it, if you created it, you're the author, then yeah, you own it.
Unless you did it under employment, in which case you might have signed a work for hire agreement where what you have created is owned by the company that you were hired by. So then you wouldn't own it. And just to go on to that question and what Louis said, you may have created it and therefore, let's say you're doing it individually, I don't know, he drew a lizard, the lizard's cool, he wants it, it's his, he owns it, that's his copyright. However, if he believes somebody has infringed on that, you can't go after them unless you federally register it. So even though you own the copyright, you can't necessarily go after them legally until you've registered it, which is the benefit of registering your copyright, even though that ownership right is created upon, that drawing when it was created.
Yeah, just to put a fine point at the end of that sentence,
Asterisk.
there's a bit of a misconception out there that you have to register something to actually have a claim in ownership and authorship, and it's just not true. Copyright is very cool in that, like, the minute it's fixated in what we call a tangible medium of expression, basically you just save it in a computer file, write it down on a piece of paper, anything that can be perceived that's not transient, like RAM memory would be transient, that doesn't work. You own the copyright in it. And registering it tells the government it's your claim to say, hey, I'm the person that created this, and if it is ever challenged, you're gonna believe me before you believe them, and it's up to them to prove otherwise. So the difference between registration and then the existence of copyright protection, which happens right away, it's an interesting manifestation in that regard.
Thank you. Mark?
I want to ask a spicy question, totally unrelated to this. So the SEC stuff that's happening, do you guys feel that that's kind of
Damn it,
just like,
bar.
do you feel that's I guess a thing that's coming from the government, like no matter what, or does it really depend on the political party in charge? Like, do our votes matter here, or is that just something that's almost inevitable?
Am I allowed to be a conspiracy theorist?
Go for it.
Who's got Tim?
Well, okay, so here's the thing, tinfoil hat on. It's just interesting to me that after all of this has happened with the regulations and the government's coming down on crypto, now you have BlackRock filing for a Bitcoin ETF. So did they create the FUD to get Bitcoin lower so they could buy in cheaper before it takes off? I don't know. But it's definitely going to be a big topic upon the upcoming election, and I would argue that, regardless of what side you're on, there's a clear separation between Democrats and Republicans and who is pro-crypto and who's anti-crypto, and I'm looking forward to seeing that line hopefully blur. But what was your question?
I don't know.
Your vote always matters.
What was your question? Yeah, your vote always matters, definitely vote.
Yeah.
Go vote.
I have a little bit of a different take. I don't think it's as partisan as it's being perceived, but I'm not a shill for one party over the other. I actually think that if I was a conspiracy person, I think there are entrenched people who benefit from the status quo, and I think no matter who's in power, they're going to bring their influence to bear on that party or whoever it is. It happens to be the blue party at the moment, but I would imagine that if this was reversed, they'd be putting pressure on them. I do think the BlackRock filing, if they get this, I mean, it is like
That's gonna be war.
it's just a slap in the face to sort of all the little guys in a lot of ways that have been trying to do this for years. But there has been, so like Richie Torres, like there's been some Ds that have really shown that they're open to a lot of this. So I don't think it's quite as partisan. I agree that right now, the SEC definitely has an agenda. That much is absolutely clear. Look, I'm a realist. It's not without some merit. Like we need sensible regulation before we're going to reach critical mass. The key word there, in my opinion, and I get it, it's just an opinion, is sensible, right? So where does that line draw? And what we've seen is that there's just sort of been this full-on assault, and I think that is being driven by the incumbents like that are in the traditional banking system. And when they get, my theory is when they get their infrastructure in place for this, then you will see politicians start to really turn. We're starting to see that now as they come in a little more. So do I think it's important? Yes, but I imagine the people that, I see people screaming all the time in Twitter, and even some pretty respectable colleagues that are like, you know, F this party or F that party, like, and my personal opinion is guys are gonna be sadly disappointed, you know,
It's not that simple.
the reaction is not gonna be quite as swift as you think it was. So I think all we can do is continue to advocate. Polygon Labs just came out with an initiative that is showing use cases, real world use cases for blockchain tech to
300 plus.
to counter the narrative that all this is a bunch of money laundering and sending money to North Korea, whatever it is. Like we all know it's bullshit, but we have to continue as an industry to sort of continue to fight the good fight, and it's hard work. It's not just sitting screaming on Twitter all day. It's doing what man's doing down in DC right now, like face to face, one on one. So it's up to us to do that.
And just because the SEC calls something a security in one of its opinions does not mean it's a security, which happens a lot. You'll see people like, oh my God, the SEC has deemed Polygon a security as it's stated in its investigation or its indictment, and that's not going to be decided just based on a filing. That's going to be decided in the court. So please don't think that just because the SEC says, again, Polygon, Solana, all of these, altcoins, XRP, all of these things, they're securities. Just because the SEC is saying that in an opinion or a complaint does not make it true.
Yeah, I mean, that exactly gets to the point I was just about to add, that this has all been going on for a while now. We've seen this Ripple lawsuit happening for years, still undecided. The fact that these complaints are just now finally being filed, Binance, Coinbase, they've been in business for a long time. The SEC has come up with whatever agenda it's come up with. They've found whatever reasons they want to cobble together, and these lawsuits are going to go on for the next likely 3 to 5 years, if I had to guess. So none of this is going to be resolved in short order. There are going to be big changes in the political power before that happens, and we may see that maybe after this next election, new administration comes into power, new SEC leadership. All of that can have ripple effects, for lack of a better way of putting it, no pun intended, on what ends up happening with these lawsuits. So stay tuned.
Well, Tyrone, you had a question like 10 minutes ago.
Yeah, I had a question about something about the AI. Rafik Anadol, he's an artist that uses Google Images to make collections with. So I was kind of curious to know who really owns that. Is it Rafik? Is it Google? Is it the person who created those photographs?
Yeah, it's a great question. So when it comes down to it, the use of an image is based on who created that image. So if the image came from Google, Google sourced that image from wherever it's hosted. That host then sourced that image from whoever the photographer was. The general rule is that the photographer owns the image, and it has to be a human photographer. So say you have a chimpanzee take your phone and take a selfie. This has actually happened. I'm referencing a real case. That chimpanzee doesn't own the copyright, but neither do you because you didn't take the photo. So it gets a little bit iffy, but to get back to kind of the meat and potatoes of it, you have whoever the photographer is, that's who owns the rights, and then if derivative works, as they're called under the law, are being created with that, then yeah, you end up in a situation where rights are kind of being infringed on and people may not even realize it. And just to take that a step further, you have training data sets that are working with all sorts of compendia of knowledge right now, images, music, text, whatever it is. We don't know what the rule is going to be on whether that's fair use under copyright law or not. There's one former general counsel of the Copyright Office who said, yeah, it's fair use, and another former general counsel of the Copyright Office said, hell no, it's not. So even the people who are doing this day in and day out have no idea which way it's going, and it's just going to come down to lawsuits.
Yeah, and just, I'm sorry.
So wait a second, so it's kind of interesting, you said that it's neither the chimpanzee nor the photographer that owns the image.
That's right. That was an actual case.
Yeah, okay, so who owns it?
Nobody, it's in the public domain.
Oh, okay.
But there was just a case decided in the Supreme Court actually about this regarding Andy Warhol and Prince.
Right.
If you'd like to get
Oh, yeah, just the short answer is, one could argue that sort of that's appropriation art in a lot of ways, and for a few years, the body of case law, particularly this case called Carrier vs. Prince, basically gave license to this transformation that was occurring and saying that could be accepted under fair use. Literally like 2 weeks ago, the monumental case came down, Warhol, the Warhol case, which basically reeled in some of that that fair use, breadth of fair use on this particular thing. Now, that case wasn't on point for AI, it had nothing to do with that, it was a traditional 2.0 case. But to your point, like, it would be interesting to see how your colleague or that artist is using it, because it's recently been reined in pretty significantly. There's some nuances, and I don't think it's worth going in, but the short of it is I'm with Lewis on this. Like, generally speaking, it's most likely subject to licensing. So I know if I was one of those photographers, the original, and somebody was NFTing mine and scribbling a few things on it, calling it their own, it's going to be a problem.
Thank you.
So I saw a recent, I saw some news about a ruling on a DAO, OP DAO, where they were ruled as a
General
person
partnership.
or like seen as a person, and I was wondering like, what do you think about like the future of DAOs and like their legal framework, so to speak? Like, how will that look?
I do this a lot. Your DAO is not a DAO. Your Discord group is probably not a DAO either. Most DAOs are more traditionally LLCs or corporations, and the only true DAO you're going to get is if you legally find an ownerless company, which right now doesn't really exist in the United States. So if I have a client comes to me and wants to be a true DAO, I send them to the Caymans, or we look at a Puerto Rican block company, because right now in the US there is truly no ownerless entity. You have these DAO, well, there's actually a really good paper by an attorney called Gabe Shapiro, and it's called The Great DAOsaster of the US. And it's because the DAO entities that are being formed in the US are literally disasters. They create a lot more problems than they solve. They have requirements that people aren't aware of. You have to like change your wallet constantly. There are different smart contract requirements, and they don't really make sense in terms of creating an efficient DAO. So if you really do want a DAO, again, I would suggest talking to legal, obviously. But yeah, it is becoming something that hopefully will be introduced here in the US. I know that I think is it Nevada that's coming up with it. Yeah, there's a couple. I think Utah, Nevada. There are a few that are coming up with DAO entities that are hopefully going to be true DAOs and doesn't leave us scrambling like, okay, well, this is what you're trying to do, so let me create an LLC, but I'm also going to create an S corp, and then we're going to create a parent company. It's kind of like this big web of lies. So it is definitely progressing, but right now, the best use case for somebody that wants to create a DAO, in my opinion, is to talk to an attorney, explain to them why you want a DAO, and it genuinely might be that you just want a partnership or an LLC between you and 4 individuals that are running the NFT or whatever you're trying to do. And that just might be more appropriate.
So just to back it up a little bit, and anybody who's not familiar with the Oogie decision, the impact of that decision and why it was so sort of kind of shook the foundations of DAO law is that Oogie, being the DAO that it was accused by CTFC of selling unregistered commodities. And they served the DAO through its chatbot, which was in of itself pretty precedential. That was a really unheard of thing. Yeah, and the judge said, it's good for me, good enough for me. And we're like, what? Like, that completely goes against the notions of due process and service. No, but that was one thing, right? So we have that to contend with. Now, this was in, I think, Vermont or New Hampshire, one of the Vermont, it was up northeast.
Somewhere in New England.
Yeah. But the other thing that later came down the line is they tried to hide behind this amorphism of this idea of like, can't catch us, there's no one here to like sort of get to, like just goes into the ether. And the judge in that case basically came down and said, nope, that's what looks like a common law partnership to me. And it's everybody who had governance tokens. So people that had nothing to do with made no decisions, no nothing, just held the governance tokens, were now all of a sudden, at least according to this judge, considered a partner, which, if you guys know anything about partnership law, gives you full liability for all of personal liability for all of the liabilities of the partnership generally. So it's scary in a lot of ways. And there was no one to defend it, and they defaulted. So right now, it stood for the proposition that like a DAO, just like a common law, it's not even, see this thing, we're struggling with these terms already, but a DAO that is not registered under one of these state-recognized LLC laws, or well, DAO laws, is, at least in this instance, has been perceived as a common law partnership, which opens up every token holder to liability for the entire, owing the amount that's owed under that violation.
It puts your holders at risk for being liable to decisions that they had no say in or, had no interest in or didn't even know were happening. So, I hope we answered your question.
Yeah.
We go on these tangents and I don't even remember what the original actual question was. I'm really sorry. Do you have anything to add to that?
Yeah, we're lawyers, we're really good at tangents.
My duty is unparalleled today. We're just going with it.
So we're running
Another
short
question
on-
from here.
My bad. Ian?
Just really quick. So what happens then, like, similar to like the tornado cash stuff that's going on, where you can send someone money through tornado cash, and then they're like held liable. Like, what if someone sends you a bunch of governance tokens, and now you're like getting sued or whatever?
It sucks.
Great question.
Yeah.
That sucks.
I mean, there's questions of dominion and control, but, and sort of volitional conduct, I would argue. If you can demonstrate like, these just appeared, I don't know what that would, but it's a great question. It's certainly with this tech, it's possible, and I love the question.
Yeah, airdrops happen all the time, and obviously we know that you don't ask for most of the things you're airdropped. That doesn't mean that you can't necessarily have some consequences for them. We see that all the time in sort of the Web3 sense. Unfortunately, it looks like right now that can happen in the legal sense too. So just be wary and get a good lawyer if you need one.
I have a question. Do you feel like traditional lawmaking will change in like the next 5 to 10 years based on Web3?
I would say if you look at the average age of Congress, no. And I mean, I wish the answer were yes, but right now Web3 is not a strong enough cultural wave to create changes in Washington that way. Maybe that'll happen in the next 50 years, but hopefully.
I was going to ask this before, is Congress the most, going back to the political question, Congress would be the most effective avenue for something to provide clarity around crypto, or would it be another?
They're the only one.
Yeah.
Only one, right? Because SEC can say
law and
whatever they want, it doesn't really matter.
Exactly. Like right now, for example, to answer your question directly, there's a bill being drafted, I want to say in the House of Representatives, that would define specifically where a token is or is not an investment contract, which means a security. So that would provide much more clarity than we've ever had, because right now, the Howey case that defines a security came out in the 1940s, and we're basically working with that same framework of securities law since then. Obviously, in the 40s, they were not thinking about, well, what's going to be a token, this or that, none of that existed. So laws are outdated. There's a little bit of effort to fix that, but it's moving at a snail's pace.
And just remember that unfortunately bills are not laws. So a lot of these things have been proposed, but most of them have been rejected. So I promise I'm fun at parties. I don't always have bad news, but it's just right now not swaying in our favor, and I do hope that changes.
So we have time for one last question, Suarez?
My question was on the topic of like ownership and copyright. When you mentioned, Joey, if he was working for an employer and he did something, they would own that right for something that you mentioned that he would sign.
Well, so that's in his employment agreement. It all depends on what his employment agreement says. Some of them do have those, it flat out says during your employment, anything you create while working here will be considered under like the Microsoft umbrella of IP. You don't own it, you're surrendering all of your rights. So that is pretty much known in the beginning, and some clauses don't say it. Some employment contracts don't say that, so it is dependent upon the specific contract. And let's say somebody outsources a designer for an NFT or something like that. Those are specific agreements called work for hire agreements, where you're literally having an artist sign away their copyrights. So if I'm paying, you mentioned that you're drawing right now, right? So you're an artist. Let's say I hire you to draw something for me. I'm going to ask you to sign a work for hire agreement. So in exchange for your art and your copyrights, I'm going to pay you a certain amount of money. So it depends on what the contract is.
And then what if they, like for example, same example we used, what if it was like smart contract where they might have some type of category or field they're in, but they buy a separate laptop in a separate room or something like that as a hobby, no matter what they do on their hobby in their off time, that's still considered? Oh, okay, got you.
It's just during the course of your employment.
Got you.
Yeah, so what you do after 9 to 5, unless they can demonstrate that it was in furtherance and in service or derived from
okay.
your
That was
position
good.
in the company.
Okay, got it.
I just want to add one thing. There's one point that always comes up in these conversations. Just because you own an NFT does not mean you own a copyright. I don't think it's been explicitly said in this conversation, but that's important to know with all these conversations. Owning the NFT, having it on chain, having it in your wallet, that is not the same as legal copyright ownership. It might be depending on what the terms of the sale for that NFT were, but you have to check into that specific project. There's no guarantees on that, and by default, it's not.
You have a personal license to use it in a very limited, by default.
personal license used in a very limited way. Usually, public display, if it's a piece of audio, you can play it, so forth and so on. But yeah, there's good point.
Some projects give out commercial rights, but at default, you're given a personal license.
And with that, we'll close it out. Let's give it up for our legal panel. Now we'll transition over to Mike McCoy.